Hi, I'm Dr. Hayo Kim with the Kim Center for Social Balance, introducing you to the LEAPS Sexual Harassment Prevention Toolkit for Employers. Why use the LEAPS toolkit? LEAPS works because it uses systematic data collection to drive targeted strategies that generate measurable change over time. This in turn empowers you to tangibly transform the heart of your workplace. And it is one of the few resources that allows you to tailor your approach with tools that fit your needs. The toolkit's various sections give you key materials such as how employers benefit by preventing sexual harassment, legal requirements, and templates and strategies to get you started right away. This toolkit is a call to action. Together, let's disrupt a relentless cycle and build ecosystems that encourage workers of all backgrounds to thrive.
Kelly Jenkins Pultz here to talk further about the laws, legal definitions, and at a minimum, your legal obligations. As your firm develops a policy to prevent and respond to the harm caused by sexual harassment, it's important that you understand the state and federal laws that apply to your organization. The legal definition of sexual harassment takes an expansive view of the number of situations and relationships among people in an organization that could be covered. In addition to situations between workers and supervisors, people at every level in your organization, including board members, clients, customers, and interns, deserve to work in an environment free from hostile working conditions based on their gender. Note that we aren't talking about sex. We're talking about an abuse of power. Sexual harassment is often used as a tool to make someone uncomfortable, ashamed, or fearful. In an organization, sexual harassment detracts from mission and purpose. It requires an intentional strategy involving transparent input from all corners of an organization and safe avenues for open dialogue. In addition to defining sexual harassment broadly, California law also mandates interactive training for supervisors within 6 months of hire or promotion and retraining every 2 years. For non-supervisory employees, the law requires 1 hour of interactive training. Training is important because it helps everyone understand what is and what is not appropriate, and it lays a foundation for dialogue and conversation that will help resolve situations if and when sexual harassment issues arise. SB 553 also requires employers to establish a workplace violence prevention plan that extends protections against sexual harassment even further. An effective sexual harassment policy will be an important centerpiece within an employer's workplace violence prevention plan. Policy and prevention are essential, but the Equal Employment Opportunity Commission also requires employers to take action when sexual harassment is reported. Investigate and take action immediately. And most importantly, do not retaliate against the complainant. This toolkit will help organizations take sexual harassment prevention and policy obligations seriously, and it offers a significant competitive edge over those who treat it as a cost of business or worse, refuse to acknowledge it or hold themselves accountable. Benefits for strong sexual harassment policies include reduction in liability risk, preservation of human and monetary resources, and positive reputation with clients and customers.